All right. Welcome, everyone. Hello. I'm going to go ahead and get started. People may be coming in as we go, and I think that's fine. But since we have a number of really interesting speakers and not as much time as any of us would like, I'd like to go ahead and get going. For those of you who don't know me, my name is Amy Coppell, and I am the director of UF's Jean Monnet Center of Excellence and the Center for European Studies. The UF Jean Monnet Center of Excellence is funded by the European Commission and is a center, an Erasmus Center of Excellence. It is part of the Jean Monnet in the US network, which is a conglomerate of EU-funded Jean Monnet programs in the US. Today's event is also co-hosted by the UF Department of Gender, Sexualities, and Women's Studies, with support from Beyond 120 and the UF International Center. A few housekeeping notes before we begin. Today's talk will be recorded and will be available on the UF JMCE website. We will have a Q&A session following the presentation moderated by Maddie Coy. However, that question and answer session will not be recorded. I want to thank you all for joining us today to discuss understanding gender inequality views from the EU, the US, and the UK. This panel is part of our EU in the News Forum series, which examines pressing issues that are facing both the EU and the US, with topics ranging from preparing for the next pandemic to legislating anti-discrimination. For details on other panels, including next semester's competing approaches to AI regulation, please visit jmce.ufl.edu. Our panel today includes two guests and one UF speaker, as well as our moderator. We have Holly Dustin. Holly, you are. Holly Dustin, who currently works as the Cultural Transformation Projects Lead for the UK Parliament and House of Commons. She was previously the Steering Group for Change Lead in the UK House of Lords and a committee specialist in the House of Commons. Before working for the UK Parliament, she served as a campaign manager and then director of the End Violence Against Women Coalition, also in the UK. Janet Beach. Janet? OBE has more than 30 years experience in UK government and the Westminster Parliament as head of gender mainstreaming, working across all ministries to incorporate a gender perspective into laws, budgets, and policy. As director of the UK Women's National Commission, advising ministers on women's concerns, and as a specialist advisor to the Women's and Equalities Parliamentary Committee. She is a gender associate of the British Council and chair of the UK Women's Budget Group, which undertakes gender analyses of government economic policies. She also delivers training on gender mainstreaming and gender budgeting in the UK, the Middle East and North Africa, Eastern Europe, South America, and Asia. Joining our panel today from UF, we have Professor Vinaya Wright, who is a professor, is formerly the T. Terrell Sessoms and Gerald Sohn Professor in Constitutional Law, and also serves as co-director of UF Center for Governmental Responsibility. Professor Wright has published broadly on a wide array of topics, including dozens of articles in journals as diverse as the Iowa Law Review, William and Mary Bill of Rights Journal, and the Columbia Journal of Gender and the Law, as well as a myriad of others. Her work has been cited by the US Supreme Court and has numerous federal and state courts as well. In addition to UF, Professor Wright has taught at the Arizona State University Law School, Indiana University School of Law at Indianapolis, and the Georgetown Law Center. Our moderator today is Maddie Coy. There's Maddie. She is an assistant professor in the Department for Gender, Sexualities, and Women's Studies Research, specializing in research on and teaching on violence against women. Before moving to the US, she was a reader at London Metropolitan University in the UK, deputy director of the Child and Women Abuse Studies Unit, where from 2006 to 2017, she worked on research projects covering a wide range of forms of violence against women, including experiences of survivors, evaluations of intervention projects, mapping of specialist support services, and discourses about child sexual abuse. Dr. Coy is a fellow of the Higher Education Academy of the UK, a faculty fellow at the Prevention Innovations Research Center, University of New Hampshire. And with all of that, I would like to now hand the microphone, metaphorically, to Professor Coy, who will be moderating and adding some information.
Oh no, I've done nothing.
Hello, thank you, Amy. I was just going to give a little bit of background about today's talk and the way that it's framed and what we're going to be hearing about from our wonderful speakers. I had known Holly and Janet for almost 20 years when Janet was head of the Women's National Commission and Holly and I both worked in the not-for-profit women's sector. And later through the End Violence Against Women Coalition, we worked together with many brilliant colleagues to hold the UK government to account on obligations to end violence against women and ensure that there was enough specialist support for victim survivors. And what we drew on in that work was human rights standards in which violence against women is understood as cause and consequence of gender inequality. And so now we're all in different roles, but our work continues to be based on those fundamental principles of human rights and gender equality. So when Professor Coppell first asked me to suggest experts on violence against women in the EU, knowing the work that you both did, I thought of you. And during our first conversation all together, it became really clear that connecting violence against women to gender equality is not the public policy or understanding here in the US. So we decided that we thought that would make a fascinating transnational conversation about law and public policy in the EU and the UK and the US. And we were thrilled that Professor Wright would join us to share legal expertise on the Equal Rights Amendment. So that's why what we're going to be talking about is looking at violence against women and thinking about the lens of legal framings on gender equality. So with no further ado, I'm going to hand over to Janet Beach to give us an overview of gender equality and violence against women in Europe. Thank you, Janet.
Thank you, Maddie. It's really lovely to be here. It's such a privilege to come and talk to people, and especially to talk in English, because I go to lots of countries where we're struggling to talk to each other in whatever language we have in common, or we have interpreters. So it's a really nice thing to be able to come and speak to you. So we're going to talk, as Maddie said, about gender inequality and its history in Europe. And there are lots of interesting similarities and differences between the way in which it's interpreted in Europe and the way it's interpreted here. I work a lot in the MENA region, in Asia and in Eastern Europe, and how states and the women's movement have tackled this issue of violence has been very different. But in my experience, the similarities really do outweigh the differences. So we're going to talk about that later. Let me move on to the next. So the reason that both Holly and I are going to be using violence as our example is because it is arguably the most extreme manifestation of women's inequality. Violence is the way in which women's inequality is policed within lots of communities. These are the figures from the EU. I think they're probably still the most recent figures, but you can see the prevalence of violence. And this is what our UK independent advisor, the government's independent advisor on tackling violence against women and girls, said about this issue. And you can see again that 20% of women victims of sexual assault in their lifetime, 27% of women experiencing domestic abuse. And you can see the figures for men. Sorry, didn't have a life of its own. You can see the figures for men are a lot smaller. So we see this as a gendered crime, particularly one that is affected by men against women, and therefore it is central to any kind of gender equality thinking. And finally, just on figures, you can see here the domestic violence, the number of occasions when it's the women are prosecuted for doing this, the number of occasions when men are prosecuted, and similarly with rape, overwhelmingly a male crime. So going to the EU, which is the main kind of area that I'm going to be looking at, we have what's called the acquis communautaire, which is shortened to the acquis, and it simply means the body of law which the European community has. And all EU member states must abide by this body of law. It's extremely important because if they don't, then they will be taken to the EU court. And the UK, I think, still holds the record for having the most cases taken against it in the EU courts, because we weren't very good at complying with this when we were members, and of course we exited the EU now. The other important thing to note is, because we have this cumulative body of laws that we must abide by, that means that anyone who wants to come into the EU also has to think about how compliant they are. So accession countries who are wanting to come in, there's a real incentive to them to start thinking about this stuff. And crucially, that means thinking about violence against women and girls. So it has influence. The fact that we have this key means that it has a direct influence on women's rights and how violence has been dealt with. Okay, so the EU has been founded on a set of values which promote equality generally. And specifically, one of the founding principles for the EU is equality between women and men. It was one of the major things that they set up when they first had the first charter. And this is institutionalized. Equality between women and men has been a key driving force of the EU. And that has meant, as you can see here, there's a series of examples. That has meant that this has been an issue that has been accepted as a public policy issue all the way through. And this is another area where I said the UK has sometimes been a bit of a drag. We haven't been compliant with a lot of the things that the EU has asked us to do. And one of the things is that we didn't treat violence against women and girls as a public policy issue for a long time. Women would stand up in Parliament and talk about it, and they would be shouted down. Some of you might have seen our televised parliamentary debates. Does anyone watch those? Anyone want to put your hand up if you've seen those? And you'll have seen that they are quite rowdy, and women were shouted down for raising domestic violence in particular as being a public policy issue. But the fact that the EU took this view, it really made a difference to women's rights. And here's some things that the EU Parliament has done. Because I've only got 15 minutes, I'm not going to read out everything that's on the slides, but they're there for you to be able to take away should you wish to. And you can see the different things that the Parliament has done. I've just picked up a few of them. And what this has meant in member states is, first of all, compliance, but it also means that the law is enforced in particular ways. So the European Commission considers itself to be the guardian of the treaties. These are effectively the EU constitution. It's overseen by the Court of Justice, and they can levy fines on member states. So there are real penalties for not complying with the acquis. And it also created a whole load of case law, a huge amount of case law. Not enough time for me to go through all the things, but I am going to go through a few examples. And it's improved women's rights in the EU. Okay, so here's one example. An example not from violence in this case, but this is an example of the EU finding that this Spanish legislation was not compliant with the requirements to equal treatment. And this was an indirect discrimination. So not directly saying that women would get smaller pensions, but because women are so much more likely to be working part-time, because of the way the pension system was designed, those part-time workers were disadvantaged. So it was possible to show that women were being discriminated against. So that was a really good example of how Spanish women were left financially much better off by this court judgment, finding that the Spanish system was not compliant with EU law. These are the key objectives. So I'm saying that the treaties are based on the principle of equality between women and men, but it translates into actual work. So the EU Commission has a gender equality strategy, then these are the key aspects of it. And as you can see, there are quite a lot of them are around the economy, the labour market, and so on. But the top one is gender-based violence. And that's something that they spend a lot of money on, and they spend a lot of time thinking about how they can address it. Here's another example from Ireland, again, not a violence example, but just to show you the breadth of this. This is protecting pregnant workers and breastfeeding mothers, maternity and parental leave. All these were driven by the requirement to be compliant with EU legislation. It didn't exist before in Ireland, and it does now. And then going on to the discrimination and the violence issue, they started to think about the fact that there was a connection between domestic violence in particular and women's inequality. And you can see at the bottom is an interesting example of economic inequality being linked with more vulnerability to domestic abuse. And I don't think I've got it on a slide here, but we have very good stats from the UK about that clear link between living in poverty and being vulnerable to domestic violence and rape. So my final example is from the UK, and this is really designed to illustrate the fact that once we were in the EU, although we did resist it and had to be dragged kicking and screaming, we did eventually pass legislation that made us compliant with what the EU was telling us we had to do. And that was done in several ways, but particularly seminally in the Equality Act of 2010. So as you can see here, this offers protection on 9 grounds of personal identity, sex, race, disability, gender assignment, sexual orientation, age, religion, belief, various aspects of maternity, marriage, and disability. So those are all protected. It is illegal to discriminate against people on any of those grounds. And that's generally the case. There are a few exceptions to that, but generally that's the situation. But it also created, really importantly, what we call the public sector equality duty. And this is a public duty on anything the state does, anything the UK state does. It must not just avoid discrimination, but actively reduce inequality. So we are able to go to the courts if the government decides to do something that doesn't close the equality gaps. We can go to court and ask for that to be overthrown. And indeed, in my organisation, the UK Women's Budget Group, we took the government to court in 2012 over their state budget. And what we did was said, you haven't been compliant with the public sector equality duty on sex, on women. And those are the kind of rights that make a difference, that are really important to ensuring that women access their rights. And I wanted to show you a couple of other examples that have been driven entirely by these EU laws. This was something that our Human Rights Commission commissioned London Metropolitan University to do, and this was something that Maddie actually led the research on. And these maps that we produced, these maps that we produced, which I think I'm right in saying were done jointly with the Geography Department. These were designed to show what areas of the UK have violence against women and girls services. And you can see that there are some areas, which are the dark red ones, have almost no services. And then as you go towards the green, they're getting more and more. So if you look for the green, you can see how few there are that are more than between 14 and 20 services that are available to you locally. And this was really important for us because, and for the Human Rights Commission, because it enabled them to identify which parts of government, which parts of the country were not compliant with the public sector equality duty. So this is a really nice example, actually, not just of the EU driving these rights and improved rights, but also of the academy and non-profits. Oh, I'm being told we haven't got much time. And non-profits being able to join together to provide a visual to show where the problems exist. And if you look at it online, I think it still is available online. You can click down to individual constituency level, parliamentary level. So our members of parliament, you could then write to your member of parliament and say, look, in our area, we have nothing. Why is that? What are you doing about it? So it was a very strong campaign. And this one, same thing again, same principle, but this is services for minoritized, racialized minoritized women, and the specialist services that they need, even smaller. Now, all the mainstream services say that they will serve all women, but obviously it's really important for specialist services to be available to those who need it. And this demonstrated how far away they were from doing that. So, as a direct result, the legal obligations on services have been created. And the government now has just passed, Parliament rather, has just passed an act, which means that every local authority, every local council has to do certain things to support victims of domestic abuse. So the takeaways from this really are that the EU's founding principle, its constitution, if you like, that has driven real changes for women's equality and women's access to rights, particularly on violence against women and girls, but on a whole range of things as well. Have I overrun horribly? Great. Thank you very much.
Thanks so much. Good afternoon, everybody. As Janet said, it's really an honour to be here, and really grateful to the Jean Monnet Centre for Excellence in the Department for Gender, Sexuality and Women's Studies who have invited us. So Janet has talked about the EU's approach to achieving equality between women and men through gender mainstreaming, and how tackling violence against women is fundamental to this. And I want to spotlight the House of Commons in the UK and the UK Parliament more widely, and its approach to sexual misconduct within the institution, which you probably have read about. And I'm going to do so with reference to the EU's gender mainstreaming tool, which it developed in 2020 to enable parliaments to self-assess for gender sensitivity, which was framed within these 5 areas, and sexual misconduct falls within area 2. Women and men have equal opportunities to influence the parliament's working procedures. In fact, I think it's arguable that the UK Parliament has made such progress on policies to address sexual misconduct that it now has a world-leading, although some say flawed, system in operation. And not to forget that this is a political institution which has a long history of excluding particular groups, including working class men, Black and minority people, and disabled people, and which legally excluded women on the same terms as men until 1928. However, I will skip over the rich history of women's achievements in the House of Commons for time reasons, other than to briefly note that these include suffragette Emily Wilding Davison, who hid in a broom cupboard in Parliament on census night in 1911, so that her address could be recorded as the House of Commons. Also Diane Abbott, the first Black woman elected to the House of Commons in 1987, and Margaret Thatcher here, the first of 3 female prime ministers in the UK, and who famously appointed just 1 woman to her cabinet in over a decade in power. Now, for comparison, this is from a 2022 newspaper article about Prime Minister Rishi Sunak's cabinet, which was current until I woke up this morning to a major reshuffle in which the 4 top jobs are now held by men who went to fee-paying schools.
But whilst giant strides were made on women's political representation throughout the 20th century, arguably this was not matched by progress on women's safety in Parliament. So in 2018, a whole century after the first women were enfranchised, the House of Commons was described by former High Court Judge Dame Laura Cox as having a corrosive culture in which bullying and harassment, in particular of women, have become normalised and which cascades down through the structures. There is also a quote there from a study done from the Women's Committee in the European Parliament, which describes sexual harassment as a widespread problem in political life, where abuse of power combines with a culture of political recruitment and patronage and pressure for silence and loyalty, including delusional party loyalty. So the UK Parliament clearly not alone in facing its Me Too revelations, and indeed researchers Johanna Cantala and Valentine Berthek commented in relation to the European Parliament that it is profoundly difficult to manifest substantive change. Sexual harassment remains a deeply polarising political and gendered issue. So we know workplaces throughout the world are impacted by sexual harassment, but I think it's fair to say that the House of Commons has its own enabling features, and this includes the built environment. So Parliament's location is in the Palace of Westminster, which is a shared space between the two houses and is a UNESCO heritage site. Now, Dame Naomi Ellen Bogan, who's a judge who looked at harmful behaviour in the House of Lords, said this in 2019, that the palace is not designed to accommodate or inculcate modern ways of working. Staff work in small rooms, she noted, on long corridors, and can be physically distant from their managers and other colleagues. And she said that contributors to her inquiry told her that when doors are closed, in particular, the environment can feel threatening and inappropriate behaviour goes unobserved. Now, for historic architectural reasons, the House of Commons chamber itself is adversarial in layout, which some argue sets the tone for behaviour outside it and is not conducive to gender equality. This is a picture of the House of Commons chamber in 1834. And here it is today. And Janet also mentioned the kind of rowdy nature of debates. So those inquiries that I mentioned into sexual misconduct and harmful behaviour in around 2018 and 2019, they also reported a culture of deference, which you may not be surprised to hear, both between MPs and administration staff, but also within the administration itself. And Dame Laura Cox described this as an excessively hierarchical command and control and deferential culture, which has no place in any organisation in the 21st century. Now, at the start, I referred to the EU's gender sensitivity tool for parliaments, and there have in fact been a number of assessments of how gender sensitive the House of Commons is, using a variety of frameworks. So in 2016, Professor Sarah Childs published The Good Parliament, which is, as she described it, a blueprint for a more representative and inclusive UK Parliament. And this led to Parliament carrying out its own audit in 2018, which included data on sexual misconduct. And similarly, the Women and Equalities Committee looked at these issues in its inquiry in 2021. So within area 2 of the EU's tool on gender sensitive parliament, it asks these questions. Now, the House of Commons has not used this particular tool to self-assess, but I would argue that it performs well against these indicators. So specifically, we have an independent complaints and grievance scheme with a distinct sexual misconduct policy, which is reviewed regularly. We have a behaviour code covering the whole parliamentary community, in addition to the MP's code of conduct, There are sanctions for breaches of the independent complaints and grievance scheme, and there are also HR human resources policies that comply with harassment provisions in the Equality Act that Janet talked about, and that those address sex discrimination. But I thought it might be useful just to set out what the Parliamentary Behaviour Code says, because it covers the whole of the parliamentary community, which is around 15,000 people, including MPs, members of the House of Lords, their staff, administration staff, such as myself, pass holders from the media, contractors, as well as people who visit Parliament. So if you visit Parliament, this code applies to you. And that top bullet says that there are clear guidelines in place in how you should be treated and how you should treat others, respect and valuing everyone, bullying, harassment and sexual misconduct are not tolerated. So we have clearly developed policies according to those EU indicators. But I think arguably the approach is more developed even than this in key respects. And Janet talked about the EU's work on gender mainstreaming, and she mentioned the gender-based violence strategy as being a key objective within the EU Commission's 5-year gender equality strategy. So just to pull out those kind of key elements that the EU says it will do all it can to prevent and combat violence, support and protect victims, and hold perpetrators accountable. And I think if we use this strategic approach to map out policies and services on sexual misconduct in the Commons, it looks like this. Under prevention, there is a code. We have seminars for all new MPs, new staff, which talks about the importance of good behaviour. There is an awareness programme. There are these posters all around the parliamentary estate. We are thinking ahead to the next general election, which will be in the next year or so in all likelihood, and how that can be used as an opportunity to really change the culture in Parliament. Support and protection of victims. The Independent Complaints and Grievance Scheme has a helpline where you can report harmful behaviour, and if your report is about sexual misconduct, you can be supported through the process by an independent sexual misconduct advisor. Now, in relation to protection of victims, I think this is a really interesting area, because the House of Commons has been debating and consulting on an approach of a policy for excluding from the parliamentary estate an MP where there has been an investigation or prosecution against them for a sexual violence offence. It's not in place yet, it's yet to be agreed, but we're not aware of a similar policy in other parliaments. And again, in terms of holding perpetrators accountable, there is a well-developed scheme and sanctions in place. So just to sort of bring this to life a little bit, here is just a sample of some recent cases under the Independent Complaints and Grievance Scheme. So that under that top heading, those are sexual misconduct cases where there's been a finding against the MP and they've been suspended. I just have included the middle paragraph, which is a bullying and harassment case, because John Burke was the former speaker, the chair of the Commons, and his conduct was found to have been so serious that had he still been an MP, because by that point he'd left, we would have determined that he should be expelled by resolution of the House. And alongside that, those are obviously our internal processes, but I think the culture is such that it has enabled these criminal justice processes as well, obviously prosecutions by the police. So we've had a couple of MPs who have been convicted of sexual offences and imprisoned. I think it's always instructive to understand how change has occurred, to know what are the key drivers, and a really significant moment in the House of Commons came early in 2018 when former staff, predominantly female, gave interviews to the BBC's Newsnight programme about their experiences of bullying and harassment at the hands of MPs, and the impact of that sort of public testimony was such that a working group was set up And by July of that year, the whole scheme, the Independent Complaints and Grievance Scheme, had been agreed by the House of Commons, and it was also agreed in the Lords as well. And I think similarly in the EU, a group called Me Too European Parliament has been highly influential on processes and keeping up pressure for mandatory training for MEPs and so on. I think we also have to recognise staff groups within Parliament who have driven the analysis of sexual misconduct as a gender equality issue, particularly the unions and one of the workplace equality networks. They've given evidence to committee inquiries, responded to policy consultations and so on. And I think also the external expertise has been critical around sexual misconduct for developing very evidence-based policies, and there continues to be external expertise built into the process. And I should also say that internal structures that continue to drive change include the cultural transformation and change teams in both houses where I've worked, and as well as the sort of inclusion and diversity teams. So the landscape of policies and structures has been established very rapidly by necessity within the last 5 years, and they continue to develop. So, having made the case for the Commons and Parliament having a world-leading system, I think it's absolutely right that I should reflect on the very serious criticisms levelled by academics, victim survivors, staff groups, and so on. So we do not currently have an institutional structure on gender equality in the House of Commons, and that has been an ongoing kind of criticism. There have also been a lot of concerns about outdated practices, very kind of historic cultures and practices still. There are not enough seats for every MP in the House of Commons chamber. And one MP, a female MP, told Sarah Childs this. She said, bobbing up and down on the benches, it is sexual harassment. You find yourself sitting on a male MP's knee. So they bob to get the attention of the speaker to speak. There are a lot of kind of practices like that have been questioned. Length of investigations, lack of third-party reporting. And currently, I think there's a lot of criticism about whether political parties themselves are doing enough to ensure the highest standards of behaviour. I would say that we also know that we need to have far better diversity data so that programmes and services can be better targeted. But I'm really interested in hearing what Danea said and really interested in the discussion afterwards. So I'm going to leave it there. Thank you very much.
Thank you all. I've got a little bit of a cold, so if I have a coughing fit, I just want to apologize in advance. I'm trying to stay away from people as much as I can. I think I'm not contagious, but I think it's ironic that the US, we consider ourselves this independent renegade country, and yet we like to pride ourselves on sort of being our individualism and being forward thinking. And I have to say, I think we are behind the times from what we just heard today. So I'm going to talk a little bit about the Equal Rights Amendment, sort of, I know you've all heard of it, where it stands and why it matters, and why having it would be a really good thing. So you all know that the Constitution and the Bill of Rights do not mention the word sex or gender or women, and it was all, of course, applicable to white men until 1868 and 1870 when we got the 14th and 15th amendments. So the 14th Amendment guarantees the equal protection of the law. The 15th Amendment prohibits restrictions against voting, preventing voting on the basis of race. So after 1870, and obviously the women's movement was very active with the abolitionist movement, women were very disappointed in the 14th and 15th Amendments. They thought that women should have been recognized, that sex discrimination should have been dealt with in the Constitution. In 1873, in Bradwell versus Illinois, the Supreme Court said that the Equal Protection Clause, which granted equal rights on the basis of race, did not apply on the basis of sex. That so absolutely cut off the Equal Protection Clause as, even though it doesn't say anything in the Equal Protection Clause, it just says, no state shall deny anyone the equal protection of the law. They interpreted it as not including sex or gender. That women could absolutely be discriminated against, and it was not meant to cover them. In 1875, even though the 15th Amendment doesn't mention men, in Minor versus Happersett, the Supreme Court said, oh, no, women don't get the right to vote, but we will give the right to vote to the formerly enslaved Black men. So as you all know, in 1920, so it took, 55 years. In 1920, we get the 19th Amendment to give women the right to vote. And the idea was there was going to be a parallel equal rights amendment at the same time. So as soon as that got approved, 3 years later, the Equal Rights Amendment was first presented in Congress. It took 49 years and a technical ploy to get the Equal Rights Amendment out of Congress. So Article 5 of the Constitution requires a 2/3 vote of both houses to get a constitutional amendment out to the states. And it took 49 years for that to happen. And it finally came out in 1972. And at that time, as you can imagine, sex had actually already been added to the Civil Rights Act. So there was a lot of discussion that we don't need an Equal Rights Amendment. But those of you who know a little bit about the history of the Civil Rights Act of 1964, sex was added as a joke, as a ploy to, they thought, to get it defeated. So if we add no discrimination on the basis of race and sex, nobody would approve that. Because surely we can't have sex equality in this country. And so it was added as an attempt to torpedo the Civil Rights Act, but it ended up passing. But anyway, in 1972, the Equal Rights Amendment finally comes out of Congress. It's a very simple two-part provision. Now there's 3 parts, 3 sentences. And it goes to the states for ratification. And the state legislatures are to ratify it. Congress decided the state legislatures would ratify it. But when it came out in the preamble of the Equal Rights Amendment, there was a 7-year deadline. It said Congress, the states have to ratify within 7 years, ratified by their legislature. Now, remember, it took 7 times that amount of time to get it out of Congress, to get the 2/3 votes. But we're only going to give them 7 years for the states to ratify. So it went forward, and within just 2.5 years, we had 35 states have ratified, but we needed 38. And gradually opposition to the Equal Rights Amendment started to grow. And even after they extended the deadline by another 3 years, it never reached its 38 ratifications until 2020. In 2017, 2018, and 2020, the last 3 states ratified. And for the first time ever, we now have a really interesting constitutional conundrum. We've never had a constitutional amendment that meets the technical requirements of Article 5 not be recognized. So this 7-year deadline, the Trump administration in a legal opinion issued a legal opinion that said, we think the 7-year deadline is valid and constitutional. Now, I totally disagree. So I'm happy to talk about that at great length. But the idea that Congress can impose a 7-year limit on the states for ratification is a really ought to be troubling. to all of us, right? Because who ratified the Constitution in the first place? Who came up with the idea of a constitution in the first place? It was the states. And in fact, in Article 5, historically, there was no provision for Congress at all to have any role in amendments to the Constitution. It was all to be left to the states. But Alexander Hamilton jumped in and said, well, you know, maybe Congress should have a little, should be able to propose amendments because they're kind of closer to the action. They might see things that are wrong. But there's no question that the power to ratify is a power that resides solely in the states. So if you imagine Congress saying, here states, we're throwing out this amendment for you. We need 38 ratifications if you want to do it. You know, go for it, don't, whatever. And we're only going to give you 7 years to do it. That is such a curtailment of the state's power in constitution making. But until 2020, it didn't matter because we didn't have the ratifications. There was no standing to sue to challenge the 7-year deadline because any amendments that had already been ratified had been ratified in under 7 years, and all the others that either had the provision, had the deadline, which didn't show up until Prohibition, by the way. All of them that had the 7-year deadline either passed in less than 7 years or never got the ratifications. So the ERA is unique in this issue here. Also, 5 states rescinded their ratifications of the ERA. And a number of states rescinded the 14th Amendment, the 19th Amendment, tried to a couple of the others. But those never mattered because enough other states ratified that we didn't need those rescinding states. So now here we are, 38 states have ratified as of 2020. We have, we've met the technical requirements, but we have these rescissions that we have to deal with, and we have this deadline issue. So obviously the ERA is in litigation, right? And we're hoping, we're certainly, we know it's going to go to the Supreme Court. What's the best argument? Who knows? It's always a tough issue. But what I want to talk about in relation to this is what would the ERA mean for gender discrimination and in particular violence against women? So, you know, we have a federal system where we've got the 50 states, and they have what we call general police power. States can pass any law for any reason, as long as it's general welfare, right? They can't, certain laws they can't pass, but as long as it's for general welfare. So if the state wanted to pass an Equal Pay Act or a Gender Non-Discrimination Act, they could do that. The federal government can only pass laws if they have express or implied powers to do so. The Equal Rights Amendment had a provision that granted Congress the power to pass laws to effectuate equal rights. But of course, the ERA is not in the Constitution yet. So when the Violence Against Women Act was passed in 1994, Congress had to find a different mechanism for a different sort of power in the Constitution to allow it to pass the Violence Against Women Act. And so they used the Commerce Clause power. They said, look, violence against women has tremendous impact on interstate commerce. It has economic impact. It causes women have to cross state lines. There's economic impact that affects economies all around the country. You know, the loss of work because of gender-based violence, criminal law. You know, they did a huge amount of fact finding in order to justify claiming that Congress had federal authority under the Interstate Commerce Commission, interstate commerce power to pass the Violence Against Women Act. But in 2000, the Supreme Court struck that down. The Supreme Court, they struck down part, not all of the Violence Against Women Act. Parts of it got reenacted, but they struck that down and they said, this is not really a matter of commerce. Criminal law is local, it's state, it should not, this is not something that the federal government should have jurisdiction over or would have jurisdiction over under the Constitution. And so they don't have power to pass this law. Now, if we have equal rights amendment, a lot of people think that we could do it, right? We wouldn't, the Violence Against Women Act would be permissible under, that Congress would have the authority to pass it. So that's one implication of why we need the Equal Rights Amendment. So we don't have to contort and do it differently, try to find other powers. And a lot of people, though, have said, well, we don't need the ERA because we've got the 14th Amendment. The court finally, in about 1976, in that era, thanks to Ruth Bader Ginsburg, pre-Supreme Court Justice, she brought a lot of cases on sex discrimination and got the Supreme Court to admit that actually sex-based distinctions should be covered under the 14th Amendment equal protection provision. But the court was unwilling to treat sex-based discrimination as seriously as it treats race-based discrimination. So the court established a three tiers of what we call scrutiny. So if a state or Congress passes a law that creates a race-based distinction, the court has said the government must have a compelling interest for distinguishing on the basis of race, and they have to use the least restrictive means possible in doing so. So virtually strict scrutiny is what it's called, and it generally means the law is going to get strict. But they wouldn't use strict scrutiny on gender-based discrimination. They felt that there's too many situations where sex-based distinctions are valid primarily in things like the military, the draft, single sex bathrooms, things like that. So the court said, we're not gonna go all the way to strict scrutiny. We're gonna stop at what's called intermediate level scrutiny. And what that requires is that for a sex-based distinction, so if you think about the draft, the state only has to have an important government interest, not a compelling government interest, but an important government interest. And the law that they pass has to substantially advance that important government interest. So this is a lower level of review. So you know, there's been a lot of talk, like in the VMI case, Justice Ginsburg kind of was pushing that intermediate level scrutiny closer to strict scrutiny, but other cases they pushed it way down. The right of women to be prison guards in male prisons. The court's like, that clearly makes sense. We don't need to have a compelling or even an important government interest in making that a law that distinguishes on the basis of sex in that case. The third level is what other types of laws get, which is just called rational basis scrutiny. So if we can just kind of hypothesize a rational reason for the law, then the law is okay. So sex-based discrimination gets this intermediate level of scrutiny. If we had an ERA, it would move up to strict scrutiny. That's what everybody thinks. It would move up to strict scrutiny, and Congress would have the authority to actually pass a lot more laws that would provide for gender non-discrimination. So yeah, I mean, I think it's something of a double-edged sword, as we all know, after the recent Supreme Court decision where they struck down affirmative action. Because the court said we're using strict scrutiny for racial distinctions, racial discrimination, or racial categories, you have to have a compelling state interest. And we can't find a compelling state interest in affirmative action. Plus, we have a colorblind constitution, which they made up. But this idea that, sure, if you have a law that distinguishes on the basis of race and disadvantages the racial minority, clearly that should get strict scrutiny, and the court has said that's correct. But because of that level of scrutiny, the court has now stricken affirmative action and said, so preferential treatment for people that were historically disadvantaged by the law is now no longer possible. If we run the real risk under an equal rights amendment, if the level of scrutiny gets moved up to the same level we use in race-based discrimination, that we may find that any kind of preferential treatment or any kind of affirmative action on the basis of sex will suffer the same fate as affirmative action on the basis of race. But right now, it's not. It's at this lower level, and because it's in this sort of intermediate level, the court has allowed a little bit more in the way of both laws that distinguish on the basis of sex and disadvantage, but also those that potentially advantage women, generally speaking. So okay, that was, I think that's all I have, but I'm happy to talk further.